First of all, thank you again, everybody, for coming here on a Saturday morning for this. I'm really pleasantly surprised with the diversity of the crowd and the sheer attendance. So thanks for that. So we started the day with presentation of a purely academic literature review paper. And at the cost of sounding pompous, I have to say that I wrote, when I was writing my part of the paper, I mean, it's written jointly by Susan, me, and Pavitra. When I was writing my part of the paper, I was simultaneously watching a bail hearing of an immediate family member in one of the lower Gujarat district courts. And I felt like, okay, I'm writing this paper and there's this bail hearing going on. And I knew that he wasn't going to get bail because everybody knew that the judge was extremely anti-bail. But sure, I mean, this paper has been purely labor of love, frankly, for some of us who have actually gone through the process. Thing we did is that we demonstrated a rollout to demonstrate that academic ideas can actually have impact. And it just takes a lot more hard work to translate an abstract idea into something that can, make a difference to people's lives. And I'm glad that a lot of us believe in doing it and we're actually doing it. And finally, how to scale up the idea across case types. So the problem with academics is also that we get too focused in trying to get the best result. And it takes someone like Agami, it takes someone like Uloy, it takes someone like Second Chance and Nyaya to come and say, hey, you know what, but this is more useful in a different area. Why don't you think about that? And why can't we put our heads together and do it? So, that was the answer. Now, to come back to your question, should we take a collective process like this and ask a tax-funded organization to run it? My answer would be no, because that completely changes what kind of information is it changes the incentive for what kind of information is disclosed. It makes the information disclosure extremely dependent on one funding source, and that is, in my opinion, dangerous. So, for example, today we use Zomato, we use a whole IMDb to rate shows. Would I want to give IMDb to, I don't know, Cinema Producers Association to handle and run it? I don't think so. I think it's beautiful that this is done collectively so that there are enough interests being reflected such that no one interest prevails. So I would think that there's special value in keeping this outside taxpayers' funds, but maybe there are some other, and I'm blindsided by a lot of things. So happy to discuss this, but first instinct is, don't ask the state to run this, we'll do it. So let the community run it. So that was just one point I wanted to say, at the cost of being over deterministic. Sorry, Susan, about this, but yes. Okay, so what are at least my takeaways when we go back to XKDR office next week? What are our takeaways from this roundtable? First is, I'd really like the fact that we all are walking away from this roundtable using the metrics language. Now we are all talking about courts in, we have definitive metrics to measure courts by. We all may agree about the relative importance of some metrics versus another, but we know that that we should measure courts by metrics and not just by aggregate pendency numbers. So I think that's quite a collective achievement, and at least I'm very happy with that.
Is there a name for this?
I wanted to, but I couldn't come up with one.
I'm very good with names.
Oh, super. Okay. 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 I would like to hear some of your most wild ideas, and then we should put it up for vote.
The first idea that came to me is the lower parade framework.
The lower parade framework.
Oh my God.
No, let it not be a Bombay specific name. As much as I love Bombay, I think Pavitra had a very good idea. Yeah, Pavitra had a very good idea of calling it the Oracle. The Oracle from the Matrix, because it is able to tell us something, hopefully with more accuracy as data increases, with more about the future. But I mean, happy to hear all sorts of names. I'm very dull, so I call it court assist, but okay, whatever. Okay. Okay. So then the challenge, I think, which some of you all actually spoke about, you spoke about, is how do you translate these metrics and deliver to the last mile, right? So I think there is a community that actually does that. So I think Uloy is is exactly doing that, right? How do we make our academic paper into something that I can show my family and they will understand it, or into show my neighbor who's in a legal dispute and he'll actually be able to use it? So I think we need a lot of work on that last mile communication. You mentioned it about how do we take it to people who are a very different kind of litigant than the litigant for whom this was built, right? So that needs a lot of work. But it's a good thing that at least talking to each other. The second takeaway, I mean, at the cost of being a little philosophical about this, is what I learned, at least from this project and this conversation, is the value of incrementalism. Is that we, something like what Akshay said, right? Let not the perfect be the enemy of the good, which is that there will be some things that are just going to be incremental steps and incremental progress, but we should all take pride in that. Even if it is solving a basic thing like, oh, can you tell me whether a litigant is a bank or financial institution versus an individual? From a researcher's perspective, academic researcher's perspective, frankly, it's a very incremental question. But I think it is only when you do these incremental things will we get to the main, the big idea, right? So I think we shouldn't underestimate incrementalism and we should just go for it, however small a progress it may be. One thing that didn't come up, and I was a little surprised that it didn't, is that yes, maybe, what Pavitra said, right? Court reforms, you could say that this idea, do you abandon the idea of court reforms? I mean, are you just going to be talking about the litigant and not talking about court reforms? And I think uh, one way to think about this is that when you put up such frameworks regularly in the public domain, that in itself becomes a feedback loop for the system. And then the system picks it up and identifies the bottlenecks that this is what people are saying about us, and hopefully that motivates reform in ways that just sitting outside and prescribing things may not. But we have to try everything, and maybe this is, I'm hoping that once you start putting out such frameworks systematically year on year for different kinds of courts, I'm reasonably sure someone will pick up and say, hey, my court is not performing so well, or hey, my court is actually doing quite well and I'm doing things right? So maybe, I don't know. And finally, the community approach, right? I think I really value this community because frankly, a lot of us doing this courts work, I don't know if you all have experienced it, I have, we often feel very lonely because nothing moves. You keep at it, but years pass, nothing moves. But the fact that you're doing it in a community and the whole community is going through this, it just makes it much more bearable. And you finally get there, right? So uh, the future is interdisciplinary. It's about academics talking to uh, Uloy Labs, Uloy Labs talking to. Yeah, I mean, I gave it some thought. I trust me. Uloy Labs talking to Second Chance talking to Nyaya, all of us talking to Agami. And I think the future is interdisciplinary. Lawyers need to get out of just thinking that the justice system can only they know it the best and only they understand it the best because they experience it on a daily basis. They need to be able to step out of that comfort zone and be able to talk to different people who may have a very different way of solving the problem that they themselves have been trying to solve. So I would like to just end with one sentence which Sachin said at the Agami Summit, and which has really inspired me, is that if you are able to keep this community going, then we ain't seen nothing yet. So yeah, thank you. Justice Sikri, may I just request you to close this?
I think, Bhargavi, you have summed up really well the deliberations which took place since morning. And therefore, I need not labor on that aspect. Coming here as a part of judiciary, if I may say so, when you talk of different divergent groups, so I can say that yes, an insider is also here who can give some of the inputs as to what is happening inside and which may help you. But as that, I would say that here, while closing, my role is now limited to which I was thinking, to just motivate you, all of you, to encourage you, to tell you that whatever you are doing is wonderful. Jay, in the beginning, when he made his opening comments, he said about the importance of economics in law, and not only in law, a very new dimension, at least for me, which he presented was that how uh, judiciary, or rather, I mean, economic considerations for which judiciary becomes relevant in resolving the cases, and how it becomes an important tool for a good governance or a democratic system, or what he called competitive political system. And therefore, it is very necessary that we have to have a judiciary which performs. We know that today there are, I mean, we are struggling with, apart from qualitative justice, but struggling with the numbers and backlog, etc. So, in that process, as I mentioned earlier, that not that judiciary is not thinking about it, not that government is not thinking about it. There have been discussions at the government level about judicial reforms, how to have speedy justice. There have been discussion within the judiciary, and from time to time, various measures are adopted, where many studies are made, I mean, undertaken, many reports are submitted on, but at ground level, or if I may say so, when it comes to results, at least we are not able to see much. And as I said earlier, also, good thing about this project, which I feel, is that for the first time, somebody is looking into the matter from consumers' point of view, consumers of justice, from litigants' point of view, which is very, very relevant. And let me here tell you my experience, first as a judge, and when it comes to, I mean, the first of all, as I said, from consumer point of view, and taking into consideration this kind of research and economic considerations, etc., putting that into. I have been saying so as a judge, and have said in quite a few judgments as well, that how economics or economic considerations are so relevant in judicial decision making as well. And of course, I was also influenced by Posner and others. I've been studying that, and then when I got a chance in first judgment, that Shiv Shakti, and thereafter in few other judgments also, I wrote in detail about it. And I give you, when it comes to from consumer point of view, the example of, although you have been discussing as a mode of settlement of disputes, that is ADR, or I come to mediation. What is the uniqueness of mediation? Uniqueness of mediation is this only, that it looks into the dispute, it looks into what could be the best solution, because I'm not going into the details of mediation, but it looks into all this from the litigant's point of view. It gives a prominent role to the litigant in resolving the dispute. I have been saying so, and I tell the judges when in judicial academies, when I go there, I've been going from last 15, 20 years now for judicial training, that look, what happens in the courtroom. Although we are deciding the cases of two litigants, but the main players in the court are the judge and the two lawyers. As far as the two litigants are concerned, or their representatives, they are sitting at the back. And I say, just see the pathetic situation or condition of those litigants. Even if they want to say something, in this all adversarial system, what happens? Those litigants, at the most, previous evening, you brief your lawyer. Your lawyer will also hear only that he thinks is relevant. He is also not, I mean, at fault, because a lawyer knows what the Evidence Act is, what is relevant fact to be proved in a case, and he would not like to listen to other things. So, therefore, a person whose case is, who wants a resolution of his dispute, he is not given that kind of, I mean, hearing or his involvement in that process. I always say that, look, his role comes only when he is to give evidence. That too, which is tutored, in the sense that lawyer says you have to say this and not beyond that. And I have seen the cases, and we all know that, the lawyers who know, if a litigant who is present in the court, his lawyer is presenting the case, is not able to say something factually or other, he wants to say, the judge will say, shut up, sit at the back. Your lawyer is there, let him argue. Maybe for the purpose of maintaining discipline or that kind of environment in the court. But he is not given any say. And he'll say, okay, if you want to argue, change your lawyer. First, remove your lawyer, and then I'll allow you to argue. Which doesn't happen in mediation. I always say that, look, in mediation, the mediator hears the two litigants to their heart's content, whatever they want to say, relevant, not relevant, because from there only mediator is able to find a solution which may not be even possible in adversarial system. Because in adversarial system, when the judge decides the case, judge will say whether the plaintiff is right or defendant is right. And we go into the past, who was right, who was wrong, who committed wrong, and because of that, what relief is to be given, which doesn't happen. And in mediation, apart from these, there may be 20, 30 types of solutions which may be possible, which are discussed, and the parties themselves choose which is good for them if the settlement arrives at. That is what you are doing when you see it from consumers' point of view. So it is from that larger picture which you are presenting from consumer point of view, and therefore I feel that this research is going to be really, really, and the work which you have done up to now is of tremendous importance. And therefore, I must say I congratulate Excadia, Agami, and all others diverse groups, as you have said, who have come, but with a common purpose, common intent, and the kind of commitment which I have seen since morning. I mean, I'm really impressed with that. And I feel that with this, we some of the comments which I have already made over it, I mean, when the discussion was going on, and I need not say much on that. But last thing which I would say here is this: you have been discussing about at the end, when Bhargavi, you also said that whether state to be involved or not, and whether you should continue with this. I agree with you, but with one modification in that. You said that, look, once the data is there, it is available, and a particular court or a judge would be in a position to say whether I'm doing right or wrong, or another judge, yes, may say that, yeah, I'm doing very well and all that. But I'll go one step further. When you have all this research, the outcome of this research, and this data available to you, you can at least at that stage tie up with either the judiciary or judicial academies, etc., for totally different purpose. We were in the beginning, I said about reforms. You also then at the end raised the issue of reforms. You are not doing that, but this data may be much more relevant for the judiciary or the government to undertake those reforms. So why not at that stage, when you think that yes, what you have done is credible and it is very useful, then share that. It may be available, but why not share that? And I may become a bridge then between you and the judiciary or the government, and say, involve you people, where whenever they talk of judicial reforms and whatever is to be done, why not they involve people from you with these kinds of inputs, which you give it to them, on the basis of which they are able to undertake some of the measures which they have never thought of so far. As I can say so, because I have been involved in these kinds of exercises in various committees, in the High Court also, in the Supreme Court also, in Judicial Academy, when we talk of this training to the judicial officers, why they should not be made aware, these judicial officers or the judges, whether they are judicial officers of the district court or the judges of the High Court or even Supreme Court, that made aware of what is this happening and how it can help them. Even when, as an individual, a judge is performing her duty in the court. So it may help. So at that stage, I would say that the outcome, like we were talking about law schools, various projects, they have been giving these outcome of these projects to the judiciary, to the judicial academies, on the basis of which there have been discussions many times, yes, how we can improve the system. So your work, which I am very hopeful and confident that you are ultimately the final product which you will bring about would be of tremendous help to the judiciary. And as I mean, conclude with what Jay said in the beginning itself, that judiciary is relevant not only for because as well as when it comes to rule of law, enforcing rule of law, or better democratic system, we have always seen this from the prism of I mean, constitutional provisions, that why, how
Mm.
constitutional provision and what is the role of the judges to uphold the constitution and rule of law, which is the basic role of the judges. So we see it only from constitutional point of view. From economics point of view, what you have said, it's really a great thing, but therefore it should be shared with them, with the judicial and judicial academies. And judicial academies will be on the basis of this, as I know, I'm privy to all that, when the courses for the judges in judicial training, we have judicial academies at the state level, we have national judicial academy at the national level. So therefore it may become a source and material for them to train the judges to perform better. So at both level, at judicial level for judicial reforms generally, and at individual level for judges, their better performance in the court, at both these levels, your research may be very, very useful. So at that stage, when it comes, I think we should have it truck with the judiciary
Sure.
and the judicial system.
Okay. Thank you, everybody.